Good morning, Mr. Skeels. Could you just tell me how your client pronounces his name?
I have referred to him as Mr. Guisti.
Fine,
We
thank
should
you.
know by now.
I should.
Mr. Skeels, Judge Fabricant seems to have gone through this very carefully, and they've done about every possible thing they can do. They took the computer to the state police experts and so on and so forth, and examined the woman or re-examined the woman. What else should we do?
Well, they didn't. Unfortunately, the judge did not do this promptly, as this court ruled in the previous decision in this case. And because the judge did not do this promptly, the best evidence of what was said to the juror has been lost. The computer is no longer in existence. And the memories of those persons who made the statements to the juror have also...
But that happens all the time, not exactly in this context, but in the context of lost transcripts and everything else. And you try to reconstruct it as best you can, and it seems to me that's what they try to do here, and the result is what we got.
Unfortunately, because they waited so long, because the judge did not take the steps that should have been taken, a lot has been lost. Now, something was preserved 5.5 years after the verdict in this case. Ann Reed stated to the prosecution and defense in a telephone interview that she probably did say something to the juror to the effect that, I think you're prejudging the case. Now, I'd suggest, Your Honor, that a statement to a juror that, by an outsider, that they are prejudging a case is presumptively prejudicial, that this is the type of statement that could affect the juror's evaluation of the evidence.
And this would get you a new trial, I would take it, if you prevail, not a dismissal of the indictment.
No, I think all along we've requested a new trial, but certainly if an outsider says to a jury prior to the verdict that I think you're prejudging the case, that I suggest...
Wait, what outside influence is there? That's what I failed to see, is what improper outside influence is there on the juror? If the person says, I think you're prejudging the case, all the person is saying is saying what the judge would have said.
That could affect the juror's evaluation of the evidence.
But that's what the judge would say. I mean, in fact, the judge does say that. Don't prejudge the case. Don't talk about it with your jurors, with your companion jurors.
But the judge has a right to do that. Certainly the other jurors in the jury
room. But the outside person is simply saying something that is correct. There's no outside communication about this case.
Well, there's an outside communication by an outsider as to the juror's evaluation of the evidence in the case. I suggest...
No, it's just telling her not to prejudge the case, which is what the judge has already said.
If anything, it might have an effect beneficial to the defendant by straightening her out.
It might not have a beneficial effect. People react differently when their opinions are criticized, when their evaluation of the evidence is criticized. It might cause her to reconsider her opinion, or it might cause her to be more certain in her opinion. The problem is that this type of statement can affect the juror's evaluation of the evidence in a case.
So let's assume for a moment that that's the evidence, that that's what was said. Is this sufficient exposure to extraneous material that this case should be retried?
Yes, because I think the case law says that any statement by an outsider to a jury about a matter pending before the juror is presumptively prejudicial. I think we've quoted that time and again in our brief. And this was certainly a statement to a juror about how the...
So a statement of someone to the juror
as to
how is it going? How is it going? That's a statement, or is it going well? Or some statement to the juror, that's presumptively prejudicial?
Some statement to the juror about the case pending before the juror, particularly about the juror's evaluation of the evidence, I'd suggest, Your Honor, is presumptively prejudicial, because that can affect the juror's evaluation of the evidence. That is the problem in this case.
So let's say we agree with you. Let's say that you know, even a apparently innocuous question like Justice Cordy's, how is it going, presumptively prejudiced, because who knows that, maybe that'll trigger something in the juror. Fine, it's presumptively prejudiced, but where's the prejudice here?
Well, I think prejudice is that it may affect the juror's evaluation of the evidence. That's the problem with statements by outsiders to jurors.
But then you're
But then you
essentially
question the
asking
juror?
for any question. Any question. It's only presumptively prejudice. Then you question the juror, and we find that there's in fact no prejudice here.
Well, that's what should have been done, of course, 4 weeks after the verdict, when the defendant first filed his motion for a voir dire here to find out what had happened. Because the judge didn't take this step, because she didn't preserve the computer in the case, we don't know what statements were actually made to this juror. The outsider, Ann Reed, said that she thought probably she'd said something about the juror prejudging the case. We don't know exactly.
Okay, Mr. Skill,
Yes.
you have to be, Skills, you have to be with me. There are two different issues, one of which is we don't know what statement was made, and as Justice Glaney suggested, that's not that unusual. You try to reconstruct afterwards, and we've got a pretty good reconstruction here. And the one thing we do know, we can assume, although Anne said, I think we can presume she said, you are prejudging the case.
Right.
Okay, so now that's the record. We've now put it back together again with affidavits or whatever. Now you have, why is that prejudicial?
Because it involves the evaluation of the evidence. It may affect the juror's evaluation of the evidence. For somebody to tell a juror, I think you're not evaluating the evidence correctly.
But it's not automatic.
It's not automatic, and in any case, as somebody suggested, telling the juror to keep an open mind until all the evidence is in surely inures to your client's benefit.
It might not. It might cause the juror to people
Dig
react
in her
differently
heels.
to different.
She might dig in her heels and say, well, darn it, I don't want this aunt telling me what to do. I think this guy's guilty, and I still want to get out of here.
Now, that's the problem. It may in fact, cause the juror to react differently than.
But isn't that a factual determination for the judge to make?
Well, it can't be made at this point because it's 5.5 years later. That's the problem.
Well,
But
that-
the juror
that's a-
testified, when did the juror testify? 3 years ago?
Well, no, the juror testified in 2001. That was more than 3 years ago. The juror testified 2 years after the verdict, more than 2 years after the verdict. The juror didn't remember anything about the conversation. She thought that Ann had said something about, did you take it seriously? I suggest that's the problem. No one can
I suppose she swore up and down that she was impartial all the way through. Did she?
Well, she may have. Certainly the New York attorney advised her to tell the judge, this was prior to the verdict, to tell the judge about these communications, email communications she'd been having.
But she didn't do that.
Which she didn't do that, which should have alerted the judge right away to the fact that she couldn't really rely on the juror to disclose what the email communications were, that a hearing should be held right away, and that the computer should be preserved, and that somebody should check the computer to see exactly what email messages were received. We know about 2 of them. 2 of them were disclosed for.
Is it your position that there were more than 2 communications?
There may well have been.
I mean, isn't everybody saying there were just 2?
No, Ann Reed said she didn't remember how many messages she may have sent to the juror. The juror couldn't even remember the communication to Ann Reed initially. When she was questioned by the judge 2 years after, or more than 2 years after the verdict, she said that at first she couldn't even remember the communication to Ann Reed. She just remembered the communication from the New York attorney. Yes.
Once this thing became to the judge's attention, to your attention, to whoever it was his attention, did anyone make a motion to preserve the computer?
Yes, the defense attorney did. And this was at the first remand hearing, and the judge refused to make such an order. And
at that point, she gave it away to her brother or somebody.
Well, that was never really determined. That's another problem in this case. At the first remand hearing in 2001, the lawyer for the juror said that her little brother has a computer. Then when it came back for a second remand in 2004, actually the brother an older brother testified in 2005, and he said she never had a little brother. I'm the only brother that was alive at the time of the first remand hearing, and I didn't have the computer at that time. She didn't give me the computer until 2003.
Well, who said it went to the little brother?
The lawyer for the juror said that the little brother had the computer at the first
Maybe the
remand.
lawyer misspoke. Maybe he made a mistake when he said little brother. Wouldn't be the first time. She said, I gave it to my brother.
But her brother didn't have it. Her brother testified he didn't have it then.
Who
And he was the only living brother.
actually got the computer?
Well, that's the question. That was never gone into. The defendant wanted to find out who got the computer and what happened to the computer. The judge would not let the defendant question any of the witnesses in the case, would not let the juror be brought back at the second remand for re-questioning. So the question of what happened to the computer and who had it at the time of the first remand was never properly
But at
addressed.
some point, I thought they found the computer. Am I wrong? And had the state police look at it?
No.
That was Ann Reed's computer,
Ann
the
Reed's
attorney's
computer.
computer.
Ann Reed's
Different
computer. Okay, fine.
There's a considerable problem
Yes,
about that
yes.
as well.
This computer went to the dump and it's gone.
And it's gone, right. That's what the older brother testified. Now, the defense was not allowed to question the older brother. The judge questioned the older brother in court, and the older brother testified he was the only living brother at the time of the first remand hearing, and at that time, he didn't have the computer. He didn't receive it until 2 years later.
But he did get it.
He got it 2 years later.
But I
after the
assume
first
that what,
remand.
Mr. Skeels, as I understand it, what you're trying to suggest is that at every turn this juror has not been forthcoming about information in her possession, and that, that one should take that into account.
That's correct. I'd suggest that was aware, the judge should have been aware of that fact 4 weeks after the verdict when the defendant filed his first motion for a new trial, because the defendant at that time gave the judge the email from the New York attorney saying that she had told the juror to bring to the judge's attention the fact that she'd had received these email messages, and the juror did not do so. So the judge was certainly on notice that this juror could not be relied on to disclose the email messages she had received, and that the juror had to be questioned immediately, and that the computer should have been preserved. This did not happen. Because this did not happen, we don't know how many email messages the juror may have received, and we don't know who may have given her messages. Ann Reed said she couldn't remember if she sent the juror a second message. She couldn't really remember what the message was that she sent to the juror. She thought she probably said something about the juror prejudging the case. And I'd suggest that could well have been prejudicial. But because we don't have the computer, because the witnesses were not questioned immediately after the verdict, the juror doesn't remember what the message was. She testified at the first remand. She doesn't remember what the message was. Ann Reed isn't sure what the message was or how many messages she sent.
But she gave a pretty good sense of what the substance was, did she not?
Well, she said, I think I said something about she should tell the judge that she had these communications. And I think I'm not sure what I said about the juror prejudging the case, but I think I said something to her about prejudging the case.
Okay.
That's the problem. We don't know what that message was. It may well have been highly prejudicial. It may have affected the juror's evaluation of the evidence. I'd suggest whenever an outsider makes a statement to a juror which could affect the juror's evaluation of the evidence, that is a prejudicial statement. And it's up to the prosecution. There's a heavy burden on the government to show that, in fact, that statement was not prejudicial because no action was taken immediately after the case had been decided when the defendant filed his first motion for a new trial, as this court has held. Because the judge did not take prompt action at that time, no one really remembers what was said at this point.
Feels this communication from the juror about the trial in which she was participating and her views that she had decided that the defendant was guilty before all the evidence was in, was sent to a listserv, correct?
That's correct.
Do we know how many people were on that listserv?
We don't. The prosecution at the second remand introduced evidence from the listserv stating that they don't retain read messages more than 2 days. So the messages would have been, at the listserv at least, would have been gone within 2 days, and it would have been
But
gone.
we don't know whether it was 5, 10, or 15, or 50. We don't know how many people.
Well, the appellate decision said that there were 900 subscribers to the service.
Yes. Now, I think Ann Reed testified that, or didn't testify, but over the phone stated that you can either send them to the entire group or you can send them privately. And she apparently had sent her message privately, or she thought she had. So,
Mr. Skills, what do we do with the judge's findings here? I mean, you talk about Mitchell's testimony as being a lack of memory. The judge says that Mitchell's testimony was that there were no other communications, and defense counsel has characterized her position as a lack of memory, one way or the other. That characterization is not consistent with her testimony.
well,
And she found her fully credible. I mean, what?
I'd suggest that's not the way that the witness testified. I think I went over this in my brief, that, in fact, the witness at first couldn't even remember whether she'd had a communication with Ann Reed, and she first said, I don't remember any other communications other than the one with the New York lawyer. Her memory was then jogged, and then she
Okay,
didn't
so?
remember. But I'd suggest a lack of memory. You can't find, a judge may not make a finding because a person doesn't remember something. A judge may not make a finding that, in fact, there was no other message when the witness merely can't remember whether there were no other messages. I think that is a factual finding which is not based on evidence.
Thank you.
On the witness, we don't know, in fact, how many messages may have been received.
Thank you, Mr. Skills. Ms. Cusick?
Good morning, Your Honors. Tracy Cusick for the Commonwealth. Your Honors, in this case, it was initially remanded, and the lower court was to explore 4 areas relative to this communication, the email communication. When it was remanded again, the judge was advised that she could do more than just interview the juror involved. And since that time, we have identified the Ann of the first message and communicated with her, and she gave a detailed summation of what the substance of that communication was.
As best she could recall.
As best she could recall. She did not have a verbatim memory of it, but when asked whether she would have offered an opinion about the crime of rape, she said absolutely not. The record reflects that Ann was simply a conscientious attorney who received this message as part of a listserv broadcast about gymnastics and emailed the juror about taking her duties seriously as a juror, to which the juror then sent another email out to the whole listserv, which was apparently about 900 people, saying, Ann took me too seriously. That's the message to which the New York attorney responded, and then that attorney sent everything up to the defendant, and it got finally to trial counsel, and then the motion was brought to the judge's attention.
Why did the judge deny, did the Commonwealth oppose the motion to preserve the computer?
Your Honor, in 2001, the judge, it wasn't entirely clear on the record, the judge asked of the counsel for the juror, what about the computer, and will you preserve it? And I believe the juror said, I will preserve it, it'll stay in its present state. I don't know that it was a formal order of the court in that case. I believe the Commonwealth did oppose examination of the computer at that point in time.
It didn't stay in its present place. Somehow it meandered over somewhere else and then got destroyed.
Well, Your Honor, it's true.
Was that communication of the judge, that statement from the judge in response to a motion, which is often viewed as an order, but leaving that aside, was that communicated to this juror?
I believe the record reflects that the juror's attorney, the juror had been granted immunity of some sort. I believe the juror was present and the counsel was speaking to her at that point.
So we now have a juror that, in addition to everything else, here's a judge saying, you know, I want that computer kept, and the representation is made to the court, nothing's going to happen to this computer. And it turns out that the juror nevertheless gave it away and it was dumped.
Well, the juror gave the computer to her brother and told the brother, hang on to it. That was what his testimony was. And then a few years passed, the brother got another computer, and not thinking to inquire of the juror, got rid of that computer. But it's not clear that that computer ever actually contained this email message. We did
But
get...
in any event, the judge accepted the juror's testimony, the brother's testimony, and everybody else, so there was no intentional disregard of anything that even approached an order.
Certainly,
right?
Your Honor. The judge said that she, I believe, rejected any suggestion
Now,
that...
if the judge found this testimony of Mitchell, the others credible, which appears she did, put it into findings, that's pretty much the end of that, isn't it?
Yes, Your Honor.
But what do you do with Mr. Skeel's point? If somebody says, I don't remember something, how can that be turned into a positive finding of what the fact that can't be remembered is?
Well, Your Honor, the communication from Anne, she might say, I don't remember exactly what I said, but she didn't offer an opinion about rape. She didn't tell the juror, stay in there, make sure that there's a conviction in this case. The material issues, Anne remembers. We have Anne's computer. We've examined that. That did not yield a copy of the message. We can't get that message anymore.
How do we know, for example, that you've got some lawyers who have some criminal experience who write back and say, you know, you really shouldn't be doing this in one way or the other, and there are non-lawyers out there who might respond and say, go to it, about time we threw those guys behind bars?
Your Honor, I suggest there's nothing in this case to indicate that occurred. And
She didn't remember hearing. The only message she recalled, the juror, was when she was confronted with evidence that a message had been sent to her. She keeps saying, no, no, no. So how do we know that?
Your Honor, in context of this message, the juror sent out her initial message to which Anne responded privately. She sent out a second message saying, Anne took me too seriously. We have the New York attorney who subsequently sent this material up to the Committee for Public Counsel Services. Certainly that person is on the list. One could infer, I don't know that it was explored, that had there been some further chatter on the list relative to the juror's participation as a juror, the attorney would have forwarded that material up as well.
No, but you're just responding to an email.
To a private email.
Somebody's replying to the juror who sent out the initial email. And the juror says, in essence, I didn't get any responses, or I don't recall getting any responses. And then they show her number one, and she says, oh, yeah, I forgot about that one. Then 2 years later, or 3 years later, or 4 years later, they show her another one, and she says, oh, I forgot about that one, too.
Your Honor, it certainly seems that it's theoretically possible that something like that could occur, but in this case, this was a gymnastics chat room. These folks were talking about a gymnastics coach. This was not a forum where people would be expected to be commenting upon legal matters. So certainly, theoretically, something like that might be possible, but I suggest that everything in this case suggests that is not what occurred. The juror was writing about...
No, it's not a discussion of legal matters, but you get this email, and, you know, it's a chatter room, and you send, and it's just as likely somebody sends back and says, you know, yeah, you know, I served on a jury too, boring, or, you know, sounds bad to me, make sure he goes away for good. Or, I mean, it's not a legal chat room. It's a group of people that she feels sufficiently involved with that she writes from the jury.
Your Honor, I suggest it may be theoretically possible, but there's certainly nothing to suggest here.
It would be less theoretically possible if she'd come in and said, you know, I sent it out, I immediately got an email back, I realized that I'd made a mistake, I think I got two, pretty certain I didn't get anything else. If she had said that right off the bat, I, for one, would feel more comfortable that her memory was about as good as it can get, instead of which we have evidence that she didn't remember anything.
Is this really open to us? We have the facts that the judge found.
Well, certainly, Your Honor, I suggest that there's no abuse of discretion here. Judge Fabricant, on remand, had 9 hearings. We had the juror's brother testified. We had the communication with Anne, at which...
I mean, the credibility of Anne really isn't up to us to decide.
Well, the credibility of Anne is fine.
I mean, not Anne, I'm sorry, of the juror.
Mitchell.
Well, certainly the judge in the trial court evaluated that, and the judge found that there was no extraneous matter communicated to this juror and that no further inquiry.
But it turns out that there was another message communicated.
Well, the message from Ann, the judge was aware of that. The trial court found that there were the two communications. There was one from the New York attorney. There was one from Ann, possibly more than one communication from Ann, but I suggest the record simply reflects that she was communicating with the juror relative to take your jury duty seriously. That was her memory of it. Certainly, I suggest that we have tracked down the computer that the juror was using, which may or may not have contained a copy of this email. That computer was disposed of at the town dump, but we don't know that that computer ever had an actual copy of the message, so even if it had been preserved, it's not established that there would have been recoverable email from that computer. And, Your Honors, I certainly suggest the fact that memories might have been better in 1999 is not a basis for a new trial in this case. Certainly we've found Ann Reed, and she provided her memory of it, and there's been no suggestion made in the record that her memory was not accurate, other than it wasn't perhaps as good as it could have been, but she remembered the important part of her message. So if there are no further questions, I would rest on my brief.
Thank you, Ms. Cusick.
Thank you, Your Honor.